Well, good evening, everyone. We're Ron and Sherry Palmer, and we're going to be talking about tonight before you go to court. And first, we want to tell you what this is not. This is not a webinar on telling you what forms you need to file for divorce. This is a webinar on talking to you about the things that you won't get told about divorce when you first start the process. So if any of you are not in the beginning of the process, it's okay. You can stay here. We'll probably talk about some information that'll be good for you to refresh on, or information that maybe you didn't know yet. You'll have to excuse me, I have a little bit of a sore throat, so if my voice cuts out or I'm drinking water a lot more during this webinar, that's why. So this before you go to court webinar is going to be in order to help you not get shocked by the process. I know that when I went through it, the more I knew, the easier it was for me to stay calm and make better decisions. And that's what we hope this will do for all of you tonight. So the first thing I'm going to do is tell you that if you don't have our book or are familiar with it, we are going to be telling you some information out of it. So don't worry, we'll tell you where to get it if you want. But it's very helpful for this process. I was looking through our chapters and I thought, wow, one of the chapters actually goes over all of the topics, or most of them, that we need to address tonight. So most of the topics we're getting tonight are from chapter 2. And let me tell you why. We put a quote at the beginning of this chapter. It's called The Wrong-Headed Thinking of Divorce Courts. And the quote at the beginning says, "Today in most family law cases, attorneys are not raising a constitutional shield to protect their clients. And when they fail to do that, a very cruel thing happens. Not only are one or both parents' ability to parent their child indefinitely suspended with the state taking permanent jurisdiction of their child, but in legal terminology, they will be considered to have voluntarily waived their right to parent their child. So if any of you are going through this, you will understand what we mean by that. That's pretty harsh to say a parent has voluntarily given this up, when it was only the attorney who failed to raise the constitutional arguments. But that's the legal standard. If you are a parent not in an intact married relationship or out of one and haven't been designated the primary caregiver, somewhere along the line you surrendered your right to parent your child." And we got that quote from the National Parents Leadership Council website in 2013. We published this book in 2013. The reason that quote's important is some of you probably know, if you're in the beginning of a divorce, you probably already got designated a non-primary parent. Ron's just stepping out for a second because there's noise in the background, and we try to make it so there's as little distraction as possible for all of you. While Ron's out of the room, we just have a couple people here tonight so far. I know where one of you is at. Craig, hi Craig, as we know, we've seen you, but what about the other two? Dan and Danny, do you want to just type in the chat and tell us if you're at the beginning of the process or in the middle, if this is a modification, so we kind of know where you're at, so we know to address things that are important to you, okay? So just type that in while we're going and we'll be able to see it.
Yeah, everyone is dealing with the corruption as well. There is a lot of fraud going on and a lot of corruption. So the first thing that we are going to deal with are false assumptions that drive tyranny, right? So the first thing that happens in a lot of cases is there are false assumptions made, and some of those are that maybe one parent doesn't qualify for equal parenting because they weren't the one staying home with the child, or that maybe one parent worked a lot so they shouldn't get equal time, or that when you step into a family court, your rights are handed over to the judge. And how does that happen? Most of the time, the attorneys are not asserting that the parent has any say, has any rights,
unless they're agreeing outside of the court process, right? That's just not the right way to do things, but that is the way they've been doing things. And I'll have Ron give you a little bit of about how it got there. So we start back with English common law about over almost 300 years ago, and the way the courts were equity courts and the way they evaluated, the way they didn't have the constitutional principles to evaluate the cases. And it started off where most of the households were dominated by men. And I'll have Ron tell you a little bit about that history.
So for those of you who don't know, our legal tradition comes from England and the English common law. And what common law is judge-made law. It is the history of precedent in judicial cases accumulated over time and repeated. And what that does is establishes a pattern of justice that people can understand, they can expect, and that they can depend on. In fact, for a long time, the people in England had a choice about whether they would be judged in a common law court or in a statutory court or the King's Law Court. And usually common people chose the common law because they trusted it more, trusted statutory law made by the king and by Parliament. Now, we inherited this. We also established a constitution that established a rule of law by statute. But where a statute does not cover a certain issue, then common law applies, and we draw our
traditions from common law in the colonies, which drew on English common law. England had secular laws and ecclesiastical or religious laws. Marriage and child law began in the religious law. The Supreme Court opinions often refer back to this common law, and you'll hear them refer to Blackstone's Commentaries on the English Law, which is a book written a very long time ago about what the common law is and what it says. Common law was what people call judge-made law, and it was very common when our country was founded, and it is a legitimate part of our Constitution.
Things like marriage and family rights fell under these religious laws. And so our legal tradition regarding marriage is one of religious law in the Christian tradition, originally the Catholic tradition, and then tradition based on the Church of England when Henry VIII abolished Catholicism in England and established the Church of England. So our law codes, our family law codes in the federal statutes, they are all state laws, and our states almost exclusively are based on this English common law. There is one exception, that is Louisiana, and it's based on French law, which is radically different in a lot of ways. I grew up in Louisiana, so I'm a little bit familiar with that. But the point of this is that our preconceptions, our presumptions, our legal presumptions, and our social presumptions about marriage and about family and about parental rights are based on religious concepts, not Constitution. And that is changing. It has changed. As early as the late 1960s, early 1970s, we still had many laws in this country that said illegitimate children were second-class citizens. They had lesser rights than legitimate children. And the parents of illegitimate children had lesser rights than other parents. So if you had a child out of wedlock, that child was subject to a different set of rules than a child born in marriage. Now, by the early 1970s, a series of cases by the Supreme Court essentially abolished this concept completely under the equal protection concept, saying that all children had to be treated equally and that children could not be punished for the sins of their parents. And this is vital because what it means is that a child cannot be punished with deprivation of rights based on what its parents do. So if its parents divorce, that child cannot lose its rights, and that child has rights to you as a parent, to each of you, of the marriage, and this is vital. So the number one presumption that you have to get your head around to really understand what's going on and how it must change is this idea that your parental rights come in any way from your marriage. They do not. They cannot. It is completely and utterly unconstitutional to predicate your parental rights or the rights of your child on the marriage. And that means, think this through, that means that when you get divorced, the state has zero legitimate interest in getting involved in the custody of your children. They cannot, simply because of the dissolved marriage, tell you how to raise your children or take rights away from you. None of that is legitimate unless they can show more. They have to show a necessity to get involved. Right? And there are a few areas where it's necessary for them to get involved when parents disagree, but that is a very small area, and those a finite number of very and specific issues.
I wanted to also tell everyone that's here, we are not lawyers. We don't practice law. Nothing we say here creates any kind of legal relationship. We can't tell you what to do. We study the case law. We consider ourselves constitutional experts and scholars. So anything that we're telling you, you're responsible to make sure you research this before you apply it to your case. We do not know the circumstances, the nuances, and even if we had details about your case, you are still responsible to make the final decision. So you're responsible to do your own research as well and make sure that it's right for you.
And keep in mind, there are 50 different states. It's impossible for us to keep abreast of these statutes in 50 different states. But what we can keep abreast of is what the Constitution says and what the federal courts interpret the Constitution to mean. And that dictates what your states can and can't do. That sets the boundaries within which your state has to operate. And we can help you understand that. We can educate you on what that means and how that applies to you.
Right. And keep in mind, the courts will tell you, no, that's not the case. It's a state issue. They'll try to tell you that your rights are just you thinking about yourself. So there's lots of ways.
Yeah, that's one they love to say when you assert your parental rights in court. They like to say, oh, you're just thinking about yourself. You're not thinking about the best interest of the child. How horrible you are by only thinking about yourself.
Yeah,
but that's a false statement, because the only way you can protect your child, particularly from unwarranted invasions into your child's privacy by the state, is if you have fundamental rights that protect you from the state.
Right. So when an attorney tells you, don't bring up your rights, you're going to piss off the judge. Well, your rights happen to be the only thing that allow you to protect yourself and your child. So when you're told not to bring that up, they're just telling you they don't know how to use this. They're also telling you they're scared because they know the judges don't have to follow your rights because it's not in statutes, and we know that there are judges who are just using statutes when it's convenient for them. They'll go outside of them when it's convenient for them, but they're certainly not going to do something if they don't feel like it, if they're not required to. So if statutes aren't requiring them to do it, we found that a lot of judges just deny you when you raise your rights. That does not mean don't raise your rights, because the attorneys are operating that way. They're saying don't raise your rights, they're not going to care, and they're just going to deny it. You don't care if they're, I mean, you wish they wouldn't, but you do not care if they are going to deny it. A denial of your rights is not a waiver of your rights. There's a difference.
It's actually error by the court, and it's error that can be overturned on appeal. It's error that can be overturned by federal courts. Now, the problem is these attorneys don't know how to make these arguments. They don't know how to get in the federal courts and make these arguments. And we are pioneering paths into doing this.
Yeah, so by the way, if you guys are not on our mailing list, get on it, because we are developing a brand new tool that we just started today about how to get into the federal courts. We think, we can't tell you for sure yet, but we think the gates have just been opened up for a lot more people to be heard on these federal rights questions.
And these state judges can be forced to follow the Constitution if you get this into either an appellate court, the state appellate court that tells them they have to, or a federal court that tells them they have to. A federal court can actually put an injunction on that judge and prohibit that judge from doing things that are specific things that that federal court has determined are unconstitutional. And if the judge does it, that judge will be hauled in front of the federal court and potentially put in jail.
Right.
So they will follow it if a federal court tells them to, because it's just like the state court telling you to do something. If you don't do it, you go to jail for contempt. Well, these judges can be held in contempt in federal courts.
Right.
And
We
this
won't
is-
go into too many details on it yet.
Right, and this is something pretty new. Most people don't know this. We didn't know this until very, very recently. All the research we'd done until very recently said that you could not have an active case in the state system if you wanted to get into a federal court. We have found a pretty recent Supreme Court opinion that says that is not the case, and that you can simultaneously have cases in the state court and the case in the federal court.
Right. That's all we're going to say about that tonight, because we're supposed to be going over the process when you're first getting into divorce. But we wanted to let you know about that's newly developing for us. We're going to be creating tools and arguments that you can use to get in and to use that process.
The reason that's important is because it will force these state courts to change.
Yeah.
If you assert your rights, and as you and others get these things before federal courts, we're actually before a federal court right now seeking to change the nature of this in Texas. But as more and more of this happens, these state courts will respond. They will have no choice but to respond, and the system will change. But it requires a lot of parents' rights, raising them properly, and knowing how to fight for them in the
Yeah.
Thank you for watching, and if you found this video valuable, please subscribe to the YouTube channel and then go on to the next video about family court myths.